Welcome. We're wrapping up our big three submissions, looking at color additives, food additives, the GROS process, taking a moment to look at food contact substance notifications, FCNs, and wrapping it up here by looking at some additional safety considerations of these three areas, looking at the Delaney clause, looking at interim food additives, and assessing this ability for pre-market safety, in addition how post-market safety, additional studies, adverse events can lead to a change either in the submission that we'll have to do later or a complete ban for that submission that we've done. And this will wrap up our three submissions, and we'll move on to some additional smaller submissions that are part of the food landscape. And as I mentioned, so far our focus has been on safety, whether it's GROS, whether it's a food additive petition or color additive petition. That's what we're looking at. And in GROS, we're looking at safety through common use, evidence of safety, and we've done that comparison to food additive petitions. With the additive petitions, both for food and for color, we're looking at the statutory criteria that was provided in the amendment. We looked at the CFR criteria that was specific for those two categories, how we define safety, and looking at toxicity, chemical identity. All of those guidance documents that we saw come into play to determine how do we publish, how do we get information, studies that support our safety conclusion, how do we have data that supports it, what kind of data, what's the adequacy of that testing method. Overall, we're looking for this conclusion both in the statute and in the CFR that reasonable certainty of no harm in our additive petition. And with our additive petitions, unlike our GROS, we're having the FDA assess safety and set safe limits. And that's going to be a very interesting component that we'll look at now at the FDA's reluctance sometimes to see problems and still allow a product to enter the market, and it takes typically a citizen's challenge to get that from being on the market. So the FDA blinder sometimes in safety that we'll see, and then also the FDA's reluctance once something is approved to take it off market, and we'll see that with the interim food additives, which is a very controversial topic. But the FDA setting the safety puts itself in a role to take some blame when that safety comes into question later. But it takes it off of industry in some way, as long as that's an honest petition that's gone forward before the agency. And that's the question we're looking at today. What happens when the system fails? Safety is not a static concept. When we submit a petition, there could be ongoing studies into our particular substance. If it's a novel substance and it still hasn't been widely analyzed, and it's still got some long-term studies to be completed, adverse events come out, safety is constantly changing. So even though we're putting our petition together today, it's not going to be the same. And that can also be damaging. You know, these petitions for additives can take a long time to put together. You want to make sure that you have it right. And in that period of time in putting it together, there is a chance that additional negative safety data could come out, and the obligation to include that in. But really our focus here is going to be post-market and what happens to our submission, to our approval, once our post-market something has changed. And something I've alluded to in the last lecture we haven't really talked about is the Delaney clause. It was added to 3 of the adulteration amendments named for Congressman James Jim Delaney, and he was the chair of the hearings that went on in the House that led to this period of legislation between 1950 and 1960, and really pushed this idea that we should prohibit the approval of carcinogens. And so if we have a submission and we have evidence that it induces cancer, then the FDA is barred from approving it. And that's the statutory language that we have in the food additive amendment, color additive, and animal drug. And so looking at drug residues that are left on meat-producing animals. And the statutory language that's identical, the Delaney clauses are identical in each amendment, says that no additive shall be deemed safe if found to induce cancer, and it gives evidence of cancer either in humans or animals, or if there's studies that are being done, and there's some statutory language that talks about what types of studies, pretty broad language talking about the adequate evaluation of a study. So pretty broad, but if it's evidence of cancer, we can't have it in our submission. If that evidence comes back later, then there's the risk that the FDA will ban that product. Here the definitions really matter, and we've stressed that throughout the course and in my previous course as well. And this is one of the areas where that concept of is a gross substance a food additive, or by definition has it come out of the food additive amendment, because the Delaney clause only applies to food additives. So if you're not subject to the amendment, then you're not subject to this ban on carcinogens. Same for color additives. It's a little easier in color additives, but this idea of gross becomes very important, because if you have a gross substance that is found to induce cancer, the FDA's position is that it's not under the food additive amendment. So it may get provisionally listed as an interim food additive and may be regulated that way, but definitions matter, and we've seen that throughout, and this is definitely an area where that can be true. And so it's another reason not only to focus on definitions, but also really make sure that gross determination is treated as seriously as an additive petition. You don't want the FDA to come back and determine that your gross determination was inadequate or that it wasn't completed, and therefore you're either an added substance or food additive. If you're a food additive and there's a risk of evidence of inducing cancer, then you're even in more trouble than if it was just an added substance that was making it an adulterated food product. So gross is really important to take serious. And the Delaney clause has come up in a few cases. One of the interesting ones is orange number 17 and red number 19. What happened when we had the 1960s color additive amendment, there was a massive amount of coloring products on the market. I think the number was like 200 to 300 at the time. There's nowhere near that number now, so that gives you a sense of what happened. But what the FDA decided to do was provisionally list all of that coloring chemicals that had been used before, provisionally list them, conduct safety assessments on them, and put them through the color additive process that was created and get them approved in that system. But in the meantime, they could stay on the market provisionally listed. One of the safety considerations is the Delaney Amendment about carcinogens, and it provides a great deal of ambiguity, a lot of room for the FDA to maneuver what kind of studies, what kind of evidence, to what level does the study need to prove, how many subjects. There's just a ton of questions that aren't answered in the statute, a little bit in the CFR. But the FDA went one step too far in the case of orange number 17 and red number 19. They, in addition to this ambiguity in the statute, they said that the ambiguity was enough there that the FDA could determine when to ignore the Delaney prohibition and when to apply it. And it said when there's a de minimis amount of a carcinogen, basically a threshold, a tolerance of a cancer-causing chemical, then if it's such a small amount, then we can ignore the Delaney prohibition on approval for products, for substances that induce cancer, and approve it and allow it on the market. And that was what they did, and that was the argument that they made for orange number 17 and red number 19. There was some evidence that it induced cancer, but it was a de minimis risk. It was a small risk in the view of the FDA. And so when they provided a final listing away from the provisional listing and gave it approval, they ignored that prohibition in the Delaney clause because it was de minimis, and they gave it approval. Very controversial. Ended up in a lawsuit, Public Citizens v. Young. You can imagine the outcome of the lawsuit when we have in the accompanying paragraph termination. 21 CFR 81 lists those that are terminated because of the Delaney clause. 81.10 is the grade marker for orange number 17 and red number 19. Even though it was a de minimis amount, it was enough for the FDA to have grounds to ban it and to be obligated to ban that use. Very controversial because of how the FDA did it, but also controversial because we fast forward to today and we see that there are potentially carcinogenic color additives, food additives, and the FDA is not taking action. And so when is that obligation kicking in? We raised an example with the color additives in the introduction to food law course with the consumer safety report looking at some of the caramel coloring in sodas and whether or not that's a carcinogen, and does that evidence raise that level? It's a difficult question. Here it was interesting in orange number 17 or red number 19 because that evidence was present at the time of submission and the FDA attempted to ignore it. It's a little more challenging to get the FDA's attention after the submission has been approved, but if there's that evidence at the time of submission, then it's going to be, chances are you're not going to get the approval, even if it's a de minimis amount. So that's something important to consider under the Delaney clause. Even more controversial, perhaps, than the Delaney clause is this weird, non-statutory creature, interim food additives. And they're created in the CFR, promulgated by regulation in 1972. Again, not provided for in the Food Additives Amendment. Does not apply to color additives, only applies to food additives and the Food Additives Amendment. It's an interpretation of that amendment, even though it's, again, not expressly or, to some extent even implicitly in the regulation that there should be this interim food additive. But we have this new category. It's a transitional category that says you have previously been approved and on the market as GRAS, as a generally recognized safe exemption to the food additive, but now we have safety concerns. Something has come up that raises that question about safety, and we're not sure that it's generally recognized as safe. So we're going to require you to go through the food additive petition process, but in the meantime, we're going to give you approval as an interim food additive, similar to that provisional process, but a little more permanent. And so we have this interim food additive. There's a whole process that goes through, and it's really not worth getting into because it was created in 1972. It was specific to some reaction around some particular substances and not really used since then. So we have it in theory. If you had a GRAS substance that had safety concerns, the FDA could put you into this interim food additive category, and from there require you to go through this new submission process where the FDA finds, and again, remember, with generally recognized safe substances, anyone can use them. So it's not specific like a drug to one maker, but any maker of that substance that now is concerned about its continued use can sponsor the studies, can sponsor the evidence, and take on the challenge of gaining full approval, going through this interim process and eventually taking it through the full food additive petitioning process to gain approval. And like I said, used and forgotten, and really a question about why it was created and why it still is used, because really you could call it the lingering food additives list. Everything that's been on there has sat for a long time. We'll get into a case study now into one of those, and one of the more controversial ones. Brominated vegetable oil, used a lot in citrus drinks. Gatorade recently, I think it was Gatorade that recently got into some media attention because of their use of that and whether that was a good idea or not. And it's something about the separation, keeping the citrus from separating. Banned in most regulatory systems. Japan, which of course has a very strict system, the EU. I think the US is amongst a very tiny, very little list of countries that still allow its use. And it's been in limbo for 42 years. It was originally listed in that creation period in 1972. And it was originally, the question came because there were some Health Canada studies that were done, and they found BBO, which, by the way, is a chemical used in flame retardation. I forgot to mention that. So we have this flame retardant chemical in our beverages, which we can start to look at that from a consumer perspective, take off our regulatory professional hat and see that from a consumer perspective, and you can see why Gatorade would drop it. But there was evidence of cardiotoxicity that was raised by Health Canada. The FDA responded, and they put it into this interim food additive category, and there it sat. Part 180 has a very short list. I think there's 4 or 5 that are listed in that Part 180, and it has sat for 42 years. And in the article I provided for the reading, there are some quotes from the FDA talking about why it hasn't moved and why it hasn't gone through that process of gaining a sponsor and either gaining a sponsor and going through and getting final regulation as a food additive or being banned. And that's ultimately what the regulation says, is that you either get off the list or you don't be used, that you're not used as a food additive. And so quasi legal grounds, and some questionable legal grounds that the FDA is relying on, but it's likely to be challenged. It's gaining more and more attention. Consumers are more concerned about its use and, its disuse in so many other countries. So it's an interesting category. It's this great example of safety going beyond the Delaney clause, beyond concerns of carcinogens, looking at something like cardiotoxicity. But it also raises questions about the adequacy of the safety reviews conducted by the FDA. It's a great rhetorical question. Are Americans uniquely safe or uniquely not prone to this BVO chemical versus Europeans or Japanese or Canadians? What's going on that our regulatory system says that this is safe, but other regulatory systems says it's a risk to their constituents? So that's something to think about as we go through these submissions of how the FDA views safety and what types of risks the FDA will view, in addition to looking at this interim food additive process. So we'll round out our discussion by looking at food contact substances notification. We talked a little bit about this previously in saying that there is this ability to say that an indirect food additive, which is what a food contact substance would be, is GROS. And so we can do this through the GROS process. But what the FDA determined, and it just began this really, 14 years, that's a pretty short amount of time, 14, 15 years. FDA has been doing this since 2000. And the FDA determined that for indirect food additives, those that are not having a technical effect on the food, and they're really not even having a secondary effect on the food, they're just inert, we're not having migration or not a lot of migration, and they're just food packaging. And so it's low risk. And so the FDA said it doesn't make sense for indirect food additives, food contact substances, to have to go through a 2-year process to gain approval through the market. And it also doesn't make sense in some ways to have a food additive process that allows others to piggyback off of that work. So we began using these in 2000. They're much faster, 24 months, 120 days, rather than the 2 years plus. So a whole lot faster. It offers a great deal more protection for those that do the submission. And that's something that's kind of not talked about yet, that you go through this expensive, onerous process of an additive petition, and then it's public regulation. Anyone can look up the CFR section and say, great, we have this new extract, this new ingredient, and we can follow the regulation that this other company has gone through and taken the time and the work to do. Maybe there's some patent protection, maybe there's some intellectual property protection that's there, but otherwise, if that is not in place, there is no protection in the regulation because it's a public regulation and it's a global approval. If it's approved for food, anyone can use it in food as long as there are no other legal concerns outside of, like intellectual property. Here, there's some more protection that the FDA is providing. It's a specific authorization. You're not getting a listing. You're not getting a public regulation. You're getting, similar to a GROS notification, when you do that voluntary GROS notification and you get a reply back from the FDA saying, yeah, that is a correct GROS determination. Pretty similar to that, where the FDA is going to provide you a letter of authorization. It's very, very, very similar to the food additive petition. There's a Form 3480 that's required. You're going to notice when we go through the next slide a lot of similarities, a few tweaks that make it fit into a 120-day process, but overall, we're still having to meet that requirement, that reasonable certainty of no harm. That hasn't changed. We're just going through a faster process, but we still need to support that standard. So I've modified this slide a little bit, so don't glaze over, because I know I've used this a couple of times. But we're comparing the food additive petition, and we use this slide to talk about what that petition looks like. So we're kind of drafting a petition, and we're focusing on safety, We have that particular form, Form 34080. We're again having the adequacy review, and in particular, the FDA knows that it has a short time frame, 120 days, so they're going to do an adequacy review. They're going to determine if everything is there. If not, they're giving you 10 days to correct it. Pretty quick turnaround, but you have 10 days to correct it. Once you've got the complete submission before the FDA, that 120-day clock begins. So once it's received and it's complete, 120 days, you're going to have your approval or disapproval depending on what the outcome is. You're going to have that substantive review that we talked about with food additive petitions, but it's going to be tiered. So if it's a higher risk, you're going to have a greater showing that's needed to gain approval. If it's a lower risk, depending on what the product is and the substance, you're going to have potentially a more cursory review. It's still going to be substantive and you're still going to have to prove that safety, but because the risk is so low, the safety concerns are much lower, so proving that safety is going to be much easier. You get an effective letter that provides everything that you would anticipate. We've seen it in the GROS, we've seen it in food additive petitions, intended use, restrictions, labeling. All of those elements are going to be there, but rather than being in a regulation, they're coming into an effective letter. And then you can enter the market. And so that's something that's different. There's no uncertainty, there's no public comment, no objections, no hearings, no challenges. The only challenges you could face are those that we've talked about in the lecture previous: Delaney clause, interim food additive. There could be a challenge for carcinogens. There could be a challenge for other safety. And so those things can come in post-market, but here the submission process, getting to approval, you're not going to hit that hurdle of someone coming in and saying that there's an objection to that particular product or that particular substance. So a much smoother, streamlined process, which it has to be to fit into a 120-day time frame. So that's pretty good, and you can see the benefit and you can see the efficiency for the agency, and the agency is all about efficiency. The quicker they can move a process through, free up resources, free up personnel, the better they're gonna like the process. And so that's part of what this is. It isn't really anything to do with changing the safety criteria, changing the review time, the review model. It's just about changing the review time and making it efficient for the agency. So this is going to wrap up, like I said, our 3 key submissions. We've looked at GROS, we've looked at food additives. Here we're talking about indirect food contact notifications, color additives. We've looked at safety. We've looked at the safety both pre-market and now here looking pre-market, post-market through the Delaney clause, interim food additives. And what we can do now is have a discussion that looks at all of these elements. We've done a couple of case studies, but we'll do another case study in the discussion board and talk about these issues and make sure we're 100% comfortable with this. We're not going to come back to these submissions, and we're going to move on to some more submissions in the next lecture. So I want to make sure everyone's comfortable with where we are here and ready to move forward. So if you have any questions, please call or email.